never see those voxels this close, since when we move the camera back, they're barely a pixel. Nanite foliage is almost done. We are moving it to the main line as we speak, and it will be available for everyone in 5.7. Another thing I would like to share is that ray tracing and Lumen now run more than twice as fast with no visual trade-off compared to when UE5 was used. And because of that, we can now hit 60 FPS on console. And finally, we rewrote the rendering pipeline to run asynchronously so you can increase the richness of your scenes even more. Now let's talk about chaos physics. For chaos cloth, we improve our cloth-to-cloth constraint solution. This removes a lot of collision evaluation when garments are piling up and interacting with each other. Even for complex setup like Series Cape, we hit a sub-millisecond budget on PS5. With Chaos Flesh, we introduce procedural muscle activations to make deformation and motion more natural. Your artist will still have control over tetrahedral simulation and train ML models that run fast in real time. We now support the baking of fluid surface data into lightweight assets to be played back at low cost. This is going to give you high-fidelity water without the performance cost of real-time fluid simulation. For animation, we work on both performance and fidelity. Here, you can see how Siri and Kelpie match up in their interaction. Well, that works no matter the angle of approach. That's our molds character motion matching solution. We also added motion matching in Sequencer to build stitch tracks. With them, you can seamlessly transition from gameplay to cinematic. Also, we now have a secondary layer of animation driven by physics in Control Rig. We used it in Kelpie's rig to drive the mane, the tail, and the saddleback. And now, I'm happy to announce that all these features are already integrated into our new Unreal Animation framework, which we are releasing as experimental in 5.6. We built it with performance first in mind. Animation evaluation are now running in parallel off the game thread, which was our bottleneck. And for the other character systems that are just as costly, like movement, avoidance, state tree behaviors, we also move them to worker threads. This is really going to help you create scenes that are crowded and lively. Streaming has always been a big deal regarding performance. And the three biggest improvements we made are physics state creation, which now runs async, improve runtime PCG for ground scatter on GPU, and a new FastGeo plugin to stream static geometry. And just to take a different example, in City Sample, the streaming time was cut down by 90% while moving at high speed. We focus on a lot of areas for performance in 5.6, and mobile is no exception. We work on better defaults and scalability settings for mobile and minimize the default package size. We also improve our workflows with a UI refactor of the viewport toolbar and content browser, an on-device iteration workflow, and a mobile preview solution. So there you go. Unreal Engine 5.6 is all about performance, and it's available today. Please go enjoy the tech talks and session we have for you guys and come chat with us. And now, please welcome Chris from the MetaHuman team. Thank you.
This is a gag order. Hold on. Imagine the audacity of trying to gag me after you made a f***ing public post detailing everything about the case. It's so disgusting. Holy shit. I'm actually triggered. I want to do a public gag after you published your whole ass insane because now you're not happy that you didn't find anything. Now you're not happy about the public filings. Now you're not happy about how the court case is going. Like, give me a break, dude. This is so wild. This can't be real, right? This has to be a joke. What's new? What's new on the docket, boys? Comes now, plaintiff Jane Doe, by and through undersigned counsel, and respectfully request the court enter an agreed proposed order to compel lolcow LLC / Kiwi Farms to remove specified URLs that link to the video and for the imposition of costs and attorney's fees on defendant as follows. So we are trying to get a court order out of a case that doesn't involve these people at all, because they're not named anywhere in the complaint, to remove videos from the internet and then to impose those costs on me. Based request from the court. Plaintiff has been engaged in ongoing efforts for the video removed from the multiple different platforms on which it was published, including the Kiwi Farms platform. Kiwi Farms is managed and operated by lolcow LLC. The video was originally published on Kiwi Farms on November 29th, 2024. February 20th, 2025, 2 days after the complaint in this action was filed, the custodian of records of Kiwi Farms removed the original post of the video and replaced it with the following message. I don't like that they say this because I don't believe this is true. I don't believe that the original post, I don't have an account on Kiwi Farms, but I don't believe the original post was removed. Didn't they just put it behind an account wall? Like you had to have an account in order to view it? Or all my shit? So, but I like how they do this, but I understand it, Joshua. I know your game. That's cute. Try to play nice with the plaintiff to make me look bad. I'm here for it. I'm here for it. Putting the videos behind a registration barrier, in our opinion, will practice harm reduction by limiting the spread of this content to users already on Kiwi Farms who are participating in the discussion. Oh yeah, okay, so he said it in the thing. So the original post was not really removed. It was just, the original post was put behind an account wall or whatever. Although the original post, which included the link to the video, was removed by Kiwi Farms, the video resurfaced in multiple other posts on Kiwi Farms. Like, this is just a lie, but that's cool, okay. Plaintiff had a subpoena served on lolcow LLC on May 10th, 2025. The subpoena requested the production of certain documents and also the removal of the links to the video depicting plaintiff. Can you ask people, can you compel actions with a subpoena in terms of doing that? I don't know if you can do that or not. I don't know if they know they could do it or not, but whatever. lolcow LLC / Kiwi Farms has cooperated with plaintiff's requests to produce documents and has expressed its willingness to remove all specified URLs which link to the video upon receipt of an order from this court. lolcow LLC has reviewed the proposed order attached hereto in redacted form as Exhibit A and has stated that it will not object and will comply once the order. I don't even know if can they. I don't know how. Where am I? Where is that? How could they even object to the proposed order? They're not part of the case. We would get to object. Which I'm sure we will, but it's not like they have to consent to the order, to the motion to get the court order. They're not part of this case. So, okay. Plaintiff is simultaneously filing a motion for leave to file under seal the unredacted proposed order, which contains the specified URLs that link to the video. Okay. Pursuant to the local rules, plaintiff met and conferred with the defendant regarding the incident motion. That's a lie. They never talked to us about asking for attorney's fees just for the removal of her video. Okay, that's an absolute lie, but okay. Defendant does not object to the entry of the proposed order to compel lolcow LLC to remove the videos. Plaintiff also requests, I don't think we actually reached an agreement on this, but I have to go back and read my emails, but. Plaintiff also requests an award of attorney's fees and related costs pursuant to 15 U.S.C. 6851, incurred as a direct result of defendant's unlawful disclosure of the video. Excuse me. This allows you to recover attorney's fees and stuff related to your claims under this. You're filing a court order to have videos removed from the internet. It's not related to this. And two, you're not talking about anything about the defendant, about me. You're trying to compel Kiwi Farms to do something. This has nothing to do with me. You can go around the internet and fight with whoever you want, but this is not, unless you're willing to name any of these parties in the complaint, which she's not because they're a coward. Plaintiff's expenses include legal and professional services necessary to pursue removal of the unlawful content from Kiwi Farms. What do you do? A boilerplate subpoena and a couple links to videos? How much money do you think you spent on this? Okay. Although defendant has averred efforts to remove the unlawful content, he has provided no evidence of such efforts and has not succeeded in having any content removed. Well, even on Kiwi Farms, which these guys should know because they rip half their legal defense from it. I did have... there was one email shot off to Kiwi Farms through my shit, but I know he's not going to ruin my stuff. He knows it's there. He knows it's not consented. He knows all of that. I shot him an email. He didn't. He's obviously not removing any of my shit unless I literally file a lawsuit against him. But although defendant is the plaintiff was forced to act at her own expense to mitigate ongoing harm. Ooh, mitigate ongoing harm. Sounds like you are being actively harmed by somebody. Sounds like you should have a court case against them. Sounds like they should have been named somewhere on the complaint so that you could actually take real actions against them. Why isn't there a judge involved in this yet? There is tomorrow. We have our hearing tomorrow. Thank God. Thank God. The plaintiff was forced to act at her own expense to mitigate ongoing harm. The defendant should bear the cost of that mitigation. C. 15 U.S.C. Section 6851 B3AI. An individual may recover reasonable attorney's fees and other litigation costs recently occurred. Excuse me, that's if you win your case, and that's in relation to the claim against me. I don't know why they're citing. I don't know. Maybe her attorneys can't read. Like, I genuinely am not sure. Maybe they can't. I don't know. Wherefore, plaintiff respectfully requests that this court order Lawcal LLC to remove the specific URLs which link to the video on Kiwi Farms as set forth in the proposed order, impose attorney's fees and costs on defendant, and order any other relief it deems just and proper. Order granting plaintiff's motion to compel Lawcal LLC to remove these. This cause can before blah, 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 remove this stuff. And it's only her stuff, which is nice. Did they fuck up the redact? Oh my God, I don't, okay. Bro, what are these people? Okay. Can you at least proofread your orders before you submit them to the court? Plaintiff's motion to seal proposed order under seal per local rule 5.4. Pursuant to local rule 7.1A2, plaintiff met and conferred with the defendant regarding the instant motion. Defendant did not object to the proposed order being filed under seal. They're being really sneaky with their language here. We never agreed. We never agreed to any order that's going to have me paying their attorney's costs for court orders that are people that are unrelated to the case, but okay. Plaintiff's motion for protective order governing discovery by Jane Doe. Is there a certificate of conference? There might be, but they lie about what we talk about. I don't know how much I'm supposed to talk about what's being conferred about, but sometimes they just don't accurately reference what we talk about, so it's whatever, dude. Plaintiff Jane Doe's motion for protective order governing discovery. This is probably just whatever comes out of discovery can't be like shown publicly, which I imagine is probably pretty standard. Oh, response in opposition to plaintiff's motion. Oh, that's us. Uh-oh, I don't think I've read these. Yeah, have I? Oh, I might have. What's an opposition? While Bonnell has no objection to non-party Lawcal LLC voluntarily removing the video from its website called Kiwi Farms, after all, Bonnell did not publish the video to that website. Plaintiff's motion seeking a court order compelling Lawcal to do anything is improper and must be denied for several reasons. First, as raised in Bonnell's answer and explained in his opposition to plaintiff's pending motion for preliminary injunction, this court lacks subject matter jurisdiction because the federal statute under which plaintiff seeks relief was not in effect at the time of the alleged dissemination of the video. This is still true. This is fatal to the entire case, but we'll see if maybe they've got another person to come out. Second, Lawcal, a Texas-based corporation, is not a party to this case. Lawcal is free to voluntarily remove any content from its site without a court order. True. Third, the request to relief is arbitrary and will not prevent the further dissemination or republication of the video on Kiwi Farms or any other website. True, the court order is literally just saying, please remove these things, and that's it. It's not an injunction or enjoining them from future behavior. They could literally remove all those things and just immediately re-upload it, and it wouldn't matter. It wouldn't do anything. It's literally a pointless fucking court order. It does absolutely nothing, but okay. Finally, even if the court compels Lolcow to remove selected content, there's no legal basis to award attorney's fees or costs to plaintiff. Vinyl is a live streamer, political commentator, known online as Destiny. Plaintiff also is an online streamer who uses the screen name Pixie. Vinyl and plaintiff met online, blah, blah, blah. Oh, these are some basic facts. Oh, this too. These guys just, oh, dude. On May 10th, 2024, plaintiff served a subpoena on Lolcow LLC, a Texas-based company that runs and operates the Kiwi Farms website. According to plaintiff, Lolcow, quote, has cooperated with plaintiff's request to produce documents and has expressed its willingness to remove all specified URLs which link to the video upon receipt of an order from this court, end quote. To date, plaintiff has failed and refused to provide Bonnell with copies of any of the documents that Lolcow produced in response to the subpoena. They're supposed to make these available to us, but again, they just like to... I don't know what the goal is, unless it's just to try to... I actually don't know. I don't know what the goal is. To get me to lie about something or to fuck up? Read the paragraph above about the Substack. On April 9, 2022, without identifying plaintiff, Bonnell transmitted the video to an individual named Rose, whom he met online. Apart from sending the video to Rose in April 2022, Bonnell has not sent the video to anyone else. More than 2 years later, on November 9, 2024, Bonnell learned that he was the victim of revenge pornography when a trove of his personal correspondence with third parties and sexually explicit content of his, including the video, was published without his permission or consent to a website called Kiwi Farms. Bonnell does not know the identity of the person or persons who leaked and unlawfully published his content on Kiwi Farms. Regardless, plaintiff published a lengthy statement on her Substack page in which she falsely accused Bonnell of intentionally distributing the video. She also posted about the video on her social media accounts and created a Give, Send, Go page to raise money to pursue this lawsuit against Bonnell. Okay. Well, I feel like we all know these facts now. Plaintiff's attorney, Joan S. Peters, indicated that Lolcow, quote, has restricted the production of these documents to attorney's eyes only, end quote. Yeah, you can't, they don't have the authority, they don't have the authority to do that. But, okay. Without any protective order in place or any legal basis for the unilateral, highly confidentiality designation, plaintiff has taken the position that she, quote, can only share the Kiwi Farms production upon Bonnell's explicit agreement that it is for attorney's eyes only, end quote. Like, what? What is my... lawyer, what is he going to do with anything from Kiwi? I don't know how much he knows about individual accounts. Like, what? But, okay. Further, in response to plaintiff's meet and confer efforts in connection with the instant motion, Bonnell inquired whether the motion was sufficient to prevent the republication of the video. Bonnell explained that the video was published on Kiwi Farms in response to other sexually explicit videos featuring Bonnell, having nothing to do with plaintiff. For that reason, Bonnell proposed the order include in her motion and proposed order 26 additional URLs that link to sexually explicit content. Plaintiff refused to include the links Bonnell identified unless he agreed to pay her. True, and super fucking disgusting, but okay. Argument: the court does not have subject matter jurisdiction. Plaintiff alleges the court has subject matter jurisdiction because her claims arise under federal law, namely 15 U.S.C. 6851. Cardi provides remedies for conduct occurring only as of the effective date of the statute. A court must not give retroactive effect. Yeah, you can't have a retroactive law. Destiny. So their lawyers know you are a victim of revenge porn, but at the same time, they say you are the person who uploaded them. What is the point of this except maybe sharing it? It's because they're just trying to make me sound as bad as possible, and they're trying to like load on these other malicious claims because their underlying state claims require like a malicious state of mind, basically. And then they're trying to basically rope me into the damages of what would be the result of the guy leaking it onto Kiwi Farms, and then Kiwi Farms proactively hosting the content knowing that it's revenge pornography. But if they can blame all of that on me, then they can claim all of the damages thereafter were my fault. So a lot of people seem to be under the assumption that like if somebody does a bad or a wrong, and then somebody else takes those and then they radically morph them into more bads or wrongs, that the original bad or wrongdoer, allegedly or whatever, that is somehow responsible for all of the outcomes. But that's not really true. That's not really how the law works. That's not even how common sense works, but yeah. Here, Bonnell sole transmission of the video preceded the effective date of Cardi by nearly 6 months. There is no admissible evidence in the record that Bonnell transmitted the video after the effective date of the statute because the date of transmission precedes the effective date of the statute. There is no federal question jurisdiction. Lolcow is not a party of the case. A court order is unnecessary. A plaintiff served non-party Lolcow with a subpoena in Texas. According to plaintiff's counsel, Lolcow produced documents in response to the subpoena. Supposedly, we haven't seen those, so no idea. Lolcow supposedly unilaterally designated its document production for attorney's eyes only. As such, plaintiff impermissibly refuses to provide Bonnell with copies of Lolcow's production. Also, according to plaintiff's counsel, Lolcow is willing to remove specifically identified content pursuant to a court order. However, plaintiff fails and or refuses to explain why a court order is necessary or how an order from this court would be binding on or enforceable against non-party Lolcow. It doesn't even make sense. Like, imagine you're talking to them and they're like, yeah, we understand that this is like non-consensual revenge porn, but we're only going to remove it if you shoot us a court order. Like, what? It's such a crazy, I don't know, whatever. But why did the judge grant the motion to file under seal? Unless something is exceptionally wrong, usually motions to file under seal will generally be granted. It's generally you grant these things, I think, unless you are doing something like exceptionally incorrect in filing under seal or whatever. Or just like filing random stuff under seal. Was Lolcow even served with a notice of this hearing? How are they supposed to defend themselves? Why would they be served with any notices for hearings? They're not parties to the case, no. I don't think they have anything to do tomorrow. I don't think it's going to involve them at all, but. Plaintiff has not cited a single authority supporting an order compelling a non-party website operator to remove online content, whether styled as a motion to compel under Rule 37 or Rule 45 of the Federal Rules of Civil Procedure. There is no provision in either rule that permits a court to issue a mandatory takedown order against a non-party. It's just like basic, like, rules of civil procedure, I guess. I don't know, but whatever. Yet she seeks relief that is plainly injunctive in nature, right? I wonder what is the formal definition of an injunction? An injunction is a thing that enjoins. An injunction, I guess, is basically you've lost on the merits of your argument, and now you are prevented from doing some behavior, or you have to stop doing some behavior. But typically, this requires a court case to determine, right? An injunction can be given as a way to, if you've won a case, basically, but. Or an injunction might be able to compel some action as well, and not just enjoin an action, sure. Yes, she seeks relief that is plainly injunctive in nature without satisfying any of the procedural or jurisdictional requirements of Rule 65. The motion is in substance a veiled request for injunctive relief against a non-party and must be denied. Federal rules, federal FS. I'm curious what rules does this govern? When you guys take the bar, are there really, like, Rule 65, are there really, like, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10? Really? I feel like I only ever hear, like, 4 civil procedure rules, but it's probably just because I haven't obviously done a lot of court cases or whatever. Contents and scope of every injunction and restraining order. Contents. Every order granting an injunction and every restraining order must A, state the reasons why it is issued, B, state its terms specifically, and C, describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. 2, persons bound. The order binds only the following who receive actual notice of it by personal service or otherwise: A, the parties; B, the parties' officers, agents, servants, employees, and attorneys; and C, other persons who are in active concert or participation with anyone described in Rule 65D to A or B. 65D to A or B. Oh, that's this right here. So the persons bound parties, I imagine, are parties to the case, but whatever, based. Federal courts lack jurisdiction.
That's fucking loud as shit, by the way.
Peace.
So who's going to apologize on the fact that I've said it? I literally have said that Village have a max win enter for world record. I can at least chat agree that I've said that? Oh, it's pretty far. Like 15. Oh, it's pretty far. Like 15. Man, that's kind of aura though. He's gonna gut it like that though. He's gonna steal my strat. He's gonna gut it like that though. gonna steal my strat? So this guy is good, but I'm gonna be honest with you. I no disrespect though. Respect. Compared to other runners, he's clipping on terrain a lot, and he's doing a lot of stuff that I see like top runners not do. I will say that. I'm just saying. He's clipping on terrain a lot. No disrespect though. Then that's max win like 5 times in a row. Clipping on terrain a lot. No disrespect though. Then that's max win like 5 times in a row. Oh. Oh. That was unlucky, really. You didn't know the angle it was going to land at, right? Behind him, right? What? Behind him, right? What? What? Looting 3. Bro's a little bit nervous, yeah. Is he not right next to it? Oh, he's gonna do a reset. Huh? Huh? I hear it!
Oh my god! Oh my god! Oh my god! Oh my god!
Oh, but no, there's an Enderman. No?
I think we're
I mean, he's not listening to the game. I don't get it. I don't get it. I don't get it. I don't get it. Yeah, but his game is loud as fuck though. He knew he had Enderman on him, no?
Oh my god!
Oh, he hit the wrong button.
Oh my god!
Dude. Jack. Yeah, Jack. I didn't even know it was gonna throw like that. I just. This is kind of crazy though. I don't think he clicked anything. It's because there's Enderman aggro. It's right here. I'm not rage baiting. You're missing the point though.
Oh my god! Oh my god! Oh my god! Oh my god! I think we're
Chat, what's going on here? Yeah, I mean, yeah, that would probably end the category. But even then, though, there is. Well, you know what sucks about this though is that this would have killed the category, but not for the